So this is defamation for falsity, and New York Times, in allowing the advertisement by NAACP, did make a mistake of publishing that Alabama police arrested Martin Luther King more times than it actually did. So it did make Alabama police look more culpable, more blameworthy than it actually is. So how does the court get out of this? How the court, so because of that, the Alabama police commissioner, well actually to be exact, the commissioner of the police commissioner of Montgomery County in the state of Alabama received a jury verdict in $500,000. $500,000 back in 1960s, it was a lot of money. So the Supreme Court strikes down, reverses that verdict. Under what reasoning, right? So we already read the importance to democracy, of the importance of democracy, importance to democracy of a lively public debate on public issues. And of course, the conduct of public officials is very important public issues affecting a lot of people. If Alabama police can arrest Martin Luther King, 7 times, although it did it arrested 4 times, 7 times, that means it could arrest a lot of other people as freely. So it will affect a lot of people. So it is a public issue. But the response to that argument is, okay, that's fine, but you cannot you cannot conduct a public debate based on false information. What's the value of conducting lively debate on public issues when it's based on false information? What's your answer to that, or what's the Supreme Court's answer to that, right? So the Supreme Court's answer to that was page 1201, 1, 2, 3, 4, fourth paragraph. Fourth paragraph, the second line, a rule compelling the critic of official conduct to guarantee the truth of all his factual assertions leads to a comparable self-censorship. I'll skip one sentence. Under such a rule, would-be critics of official conduct may be deterred from voicing their criticism, even though it is believed to be true, and even though it is in fact true, because of doubt whether it can be proved in court or fear of the expense of having to do so. Okay, for fear of expense of having to prove in court. They tend to make only statements which is still far wider of the unlawful zone. So this is false information. This is true information. When they make statements, they'll make statements only up to here. it will steer far away from false statements. So what ends up happening is this much speech, will be suppressed because people voluntarily will censor themselves from speaking close to the line of falsity. So if, for instance, people know that Alabama police arrested Martin Luther King at least 4 times, right? At least 4 times. They know that. They know that it's between 4 times and 7 times. Now, to be steered, to be safe, instead of saying, oh, Alabama police arrested Dr. Martin Luther King between 4 to 7 times, they'll just say, oh, they arrested Martin Luther King 4 times, right? So then public will not be informed of the possibility that Martin Luther King might have been arrested actually 7 times. So that is this effect of pushing people away from the line of falsity is called chilling effect. Repeat after me, chilling effect. So this much speech is chilled. Chilled means suppressed. Now, in freedom of speech, chilling effect is a constitutional harm. It is different if we are talking about suppression of physical action. Now, let's say if you drink two glasses of beer, you cannot drive because of a drunk driving law. But to stay safe from the illegality, you drink just 1 glass of beer, right? Although you can drink 2, although you can drink 1.5 glass, you drink just 1 and don't go near 2, right? Now, nobody thinks, and no constitutional theory calls that a harm. So chilling effect on physical action is not constitutional harm. But in freedom of speech, it's considered a harm. People not being able to say something lawful just for fear, just because they're afraid of the expense and efforts to prove that they are doing legal things, that is considered constitutional harm. Why is that? Why is chilling effect on physical action considered not a harm, but chilling effect on speech a harm? Not many people know. Not many people have studied. If you pursue a PhD, that will be a good PhD topic. I've written about it, but not many people seem to wonder. I wonder. But I mean, one of the reasoning probably is because of the intellective nature of speech, right? Speech doesn't cause effect by itself. It always relies on the responses of the hearer, the person who hears the speech. Saying, oh, go kill person X, doesn't actually kill person X. If I just go kill person X, yes, I kill person X. But if I just say go kill person X, that doesn't kill anybody. Only if somebody who listens to me go kills person X, then he gets killed. So it is mediated, right? It depends on the interaction of the person who hears my speech. So, probably there is not much reason. If this much speech is taken away, if this much speech is dropped out of the universe of allowable speech, then that is just unjustified restriction on freedom of speech. Maybe that's the reason. I don't know. I haven't thought deeply about it. But what I'm trying to show you is that the standard of review on freedom of speech is much more strict than standard of review on suppression on physical action. So you can say clear and present danger test is one special form of strict scrutiny. We talked about strict scrutiny, intermediate scrutiny in the equality area, right? For equal protection right. And you can say the same thing here. I mean, you can apply the same framework here. So, I mean, if this much speech is suppressed, then this will be, in the framework that we talked about for equality, there will be what? Over inclusion, right? Regulating or restricting more speech than necessary to prevent the harm, right? Okay, so anyway, now, is there any other reason that the court gives in protecting people's right to denounce public officials with false information? Page 121 at the bottom. In Barr versus Matteo, this court held the utterance of a federal official to be absolutely privileged. privilege 면책된다는 얘기죠. The bottom paragraph, page 1201. In Barr versus Matteo, this court held the utterance of a federal official to be absolutely privileged if made within the outer perimeter of his duties. The states accord the same immunity to statements of their highest officers. The reason for the official privilege is said to be the threat of damage suits would otherwise inhibit the fearless, vigorous, and effective administration of policies of government and dampen the ardor of all but the most resolute or the most irresponsible in the unflinching discharge of their duties. Analogous considerations support the privilege for the citizen critics of government, right? Now, public officers can denounce people with immunity. I mean, not absolute immunity, but certain level of immunity. If you remember, even in Korean law, there is a similar immunity for congressmen. Now, that immunity is broader in Anglo-American governments. It extends to the administrative officials or officers in the executive branch. But in Korea, it's always the Congress people making statements in the course of congressional sessions. But what the court is saying is, hey, if public officials can, denounce private citizens with immunity, maybe private citizens should be allowed to do the same, right? That you can say something with immunity means it's okay for you to be false. Then private citizens should be able to denounce public officials with false information. Now, let me just double check on Sedition Act of 1798. Well, I talked about a little bit toward the end of the class last week. Sedition Act of 1798 basically prohibited people from criticizing the new government of the United States, the recently created government of the United States. And it was never repealed, but it was never used. That's why it was never struck down by the Supreme Court, because it was used once by George Washington, the first president. But all the sentences given under George Washington were commuted, were thrown out by the second president, Thomas Jefferson, saying, Thomas Jefferson thought that barring people from criticizing the government is just doesn't make sense. It's not consistent with the values that the new government try to put forth. So President actually pardoned. I'm sorry, it didn't actually. Of course, I mean he's a president. He cannot throw out a judgment, cannot throw out convictions, but pardoned. 사면을 해줬다는 거죠. So a paragraph below, the court is saying, hey, $500,000 judgment is just like criminal prosecution. It is as harsh as criminal sentence under the Sedition Act. And if you allow people to be hit with such harsh judgment for criticizing a public official, even if it is false, then it is like reviving the Sedition Act of 1798, because that's what the Sedition Act did. It punished people for criticizing the government. So this is like killing two birds with one stone. The Supreme Court used the opportunity to effectively repeal the Sedition Act of 1798, although it was never subject of this case. And in doing so, it used the example of 1798 to also restrict the scope of the damage lawsuit for defamation of public officials. So what's the rule then? The rule is this, the page 1201, the second paragraph from the bottom. The constitutional guarantees require, we think, a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice. Repeat after me. Actual malice. 한국 헌법 교과서에서 현실적 악의라고 번역되는 거죠. Actual malice. So many constitutional scholars in Korea believe that Korean court also adopted the actual malice standard. 그래서 여러분들 헌법 교과서 보면 공적인 사안에 대해서는 허위라고 할지라도 진실이라고 믿을 만한 상당한 이유가 있으면은 면책된다. 이렇게 여러분들 배우고 있을 겁니다. So it comes from at least the spirit of the New York Times versus Sullivan. Now there is a more, that is with the knowledge that it was false or with the reckless disregard of whether it was false or not. So that's the definition of malice. 현실적 악이라는 것은 허위임을 알았거나 또는 허위였을 가능성에 대해서 무모하게 배관시했거나 disregard. 그러니까 이게 진실하고 믿을 만한 상당한 이유. 그러니까 진실하고 믿을 만한 상당한 이유가 있다는 것은 허위임을 알았다거나 허위일 가능성에 대해서 무모하게 배관시했다는 거하고 상관이 있나요? 상관이 있겠죠. 진실하고 믿을 만한 상당한 이유가 있다는 거는 허위임을 몰랐다는 거잖아요. 그죠? 허위임을 알고 있다는 거. That you know knowledge of falsity will be negated by having a reason to believe that it was true. Right? So, but which one do you think is a higher standard? Requiring that, let's say I'm defendant. Now, plaintiff or the prosecutor have to prove that I did something wrong, right? Usually it's the plaintiff or prosecutors that have burden of proof. And in Korea, the prosecutors have to prove that I didn't have substantive reason to believe that was true. In the United States, the plaintiffs have to prove that I actually knew that it was false, or I was very reckless. I recklessly disregarded the possibility that it was false. Which one do you think is a higher standard? I think the American standard is higher. When I say higher, it's harder for the plaintiffs or prosecutors to prove. Right? Because to prove actual knowledge of falsity, they really need to establish that I knew that it was false. Right? Now, proving that I didn't have substantial reasons to believe it was true, it's easier because all the prosecutors need to do is look at on what basis I made the statements, and then just argue that, okay, that's not substantial enough. That's what happened to 정봉주 in making allegations against 이명박 or his involvement with BBK financial fraud. It's interesting because now it's being proved that actually 정봉주 was correct, because I mean he's not an expert at all in international finance, right? So he presented all these reasons why he thought 이명박 was involved with the BBK finance scandal. But the prosecutors, I mean, this was 2000, it's about 80 years ago. the prosecutors, told the court, "Oh, that's not substantial enough. That's well, number one, prosecutors show that 이명박 was not involved with BBK. Second, show that the basis for 정봉주's statement was not substantial. But what's happening now? Well, now it's being proved that 이명박 was not proved yet because he was only recently arrested. But the current prosecutors are 100% convinced that it's 이명박 that drove the BBK financial fraud. 그게 다스가 이명박이 실소유주라고 하면 BBK 주가 조작을 하는데 들어간 자금이 다스에서 다 왔기 때문에 BBK 주가 조작도 결국에는 이명박이 한 게 되거든요. BBK 주가 조작에서 나온 수익금이 전부 다 결국엔 다스로 들어가는 거였기 때문에. 그래서 now if we applied the American standard back in 2010 at 정봉주's trial, since 이명박 was a public official, right? So if the New York Times standard, if the New York Times versus Sullivan standard was applied there, the prosecutors had to prove that 정봉주 knew it was false. 정봉주 knew that 이명박 was not involved, was not the mastermind of the BBK scam, which would have been impossible for Korean prosecutors to prove because 정봉주 was not expert enough to know 이명박 was not involved with the BBK scam. See, if prosecutors worked hard to prove that 정봉주 was not expert enough to have substantial basis, right, to believe that 이명박 was involved in BBK scam, then that in itself is easily convertible into proof that he was not expert enough to know that 이명박 was not involved, right? If he was not expert to believe that 이명박 was involved, then he was not expert to know that he was not involved. So just trying to show how high the standard is. So that's the meaning of New York Times versus Sullivan. Now that standard is broadened in page 1207 to public figure that's not a public official. Curtis versus Butts in 1967. So their Associated Press published an article falsely accusing plaintiff of conspiring to fix a football game between University of Georgia and University of Alabama. By the way, still very good football teams even now. I guess they were good football teams back then. And at the time of the article, Butts was the athletic director of University of Georgia. Okay. And also, there was a companion case. Walker sued Associated Press let's see. Okay, so I'm sorry. Butts was let's see. So defendant for the Butts claim was Curtis Publishing, and defendants for Walker claim was Associated Press. And apparently these were individuals, private citizens of national prominence, not public officials. Now, so if you remember New York Times versus Sullivan, think about whether the reasoning of New York Times versus Sullivan can easily apply to non-officials. So, in New York Times for Sullivan, if you remember, page 1200, the third paragraph from the top, we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Okay. And then 2 paragraphs down, injury to official reputation affords no more warrant for repressing speech that would otherwise be free than does factual error. Where judicial officials are involved, this court has held that concern for the dignity and reputation of the courts does not justify the punishment as criminal contempt of criticism of the judge or his decision. So, do these reasonings apply also to public figures? 공인, 유명한 사람이죠. What does the Supreme Court say about it in Curtis? Page 1208, court says, many individuals who do not hold public office at the moment are nevertheless intimately involved in the resolution of important public questions, or by reason of their fame shape events in areas of concern to society at large. As a let's see. As a class, these public figures, so that's one reason, that they also can be influential as public officials, right? Public figures can be as influential as public officials. Second, as a class, these public figures have as ready access as public officials to mass media of communication, both to influence policy and to counter criticism of their views and activities. Okay. So, I mean, this is something that New York Times vs. Sullivan court did not talk about, that public officials have ready access to mass media. Is that true? Public officials have ready access to mass media, or more easier access to mass media than others? True, right? I mean, the reporters love to report on the conduct of the governments. Why? Well, because if they do something, their conduct affects a lot of people. The reporters have so much interest in Korea, in the government administration, that they even have offices, permanent offices set up in the government buildings. 프레스룸이라고 하죠. 그래서 예를 들어서 검찰 담당 신문 기자다 그러면은 신문사에 출근하는 게 아니라 그 검찰 프레스룸에 출근을 합니다. 거기서 그냥 일을 해요. And if you look at, I mean, I'm going to talk about this, but I'm going to talk about this later, but broadcasting around the world, including Korea and the US, have this rule of fairness, that when you report on a divided topic, okay, on socially divisive issue, you have to be fair in reflecting both sides of the argument. It's called fairness doctrine. We're going to talk about in like about 2 weeks from now. But if you look at how the Korean media delivers or reports on the government announcements, they just report on government announcements without really following up with the positions of people who oppose the government policies that were just announced. I mean, the classic example happened during the sinking of the Seoul ferry. If you remember, once the rescue authority, the government authority, announced that, they put in 600 people, 600 rescue personnel, and 200 ships for rescue efforts, the mass media just ate that up. They just wrote exactly as the government has announced, without accompanying any criticism from the people who thought the rescue efforts were inadequate. That is a violation of fairness doctrine. What I'm trying to say is the government does have ready access to mass media, both in Korea and the US. I mean, if President Trump does so much as yawn or drink a glass of water on the podium, that will make headlines in American media. So if there is someone who criticizes Trump, Trump can always state his position, and that will make headlines. If I criticize Trump now, what I say is not going to make headline. But if Trump notices what I said and says something on Twitter, it's going to make headline. President Trump hits back at this unknown professor from South Korea, last name Park, right? The access to the media is just unparalleled. So I guess it's something that New York Times Bill Sullivan should talked about but didn't. But the court in Curtis, just mentioned it and then used that to justify extending the Sullivan rule to non-official public figures. Okay, any question or comment about Curtis or New York Times versus Sullivan? There are a couple of minor points that you should think about. Notice that the case is not between government and an individual, right? All the cases we looked at so far were between governments and individuals. But this one is between private companies and private individuals. Not even private individual, but although it is a public official, it was really in personal capacity that he is suing, right? So this was a private damage suit. 민사손해배상인데 왜 헌법이 관련돼 있지? 그죠? 이게 이제 여러분들 그 기본권의 뭐 제3자적 효력 배울 때 3자적 효력이 있다라고 얘기를 할 때 그 증거로 뉴욕타임스 버스 설리번 얘기하면 됩니다. So the court talks about this as well. Page 1199, the bottom paragraph. We may dispose at the outset of respondent's argument. We may dispose at the outset of respondent's argument that the judgment of the state court is insulated from constitutional scrutiny because the 14th Amendment is directed against state action and not private action. That proposition has no application to this case, although this is a civil lawsuit between private parties. The Alabama courts have applied the state rule of law which petitioners claim to impose invalid restriction on their constitutional freedoms of speech and press. It matters not that the law has been applied in a civil action and that it is common law only. The test is not the form in which state power has been applied, but whatever the form, whether such power has in fact been exercised. So what does defamation judgment do? Well, it moves money, substantial amount of money, in this case $500,000, from one private person to the other, right? And that is state power. That is state action. state action이라고 그 앞에 페이지에 써있죠. state action. 그러니까 그거 공권력 행사라고 번역하시면 됩니다. 공권력 행사. 헌법 문제를 다루려면 공권력 행사가 있어야 되죠. 그죠? 네. 근데 여기는 공권력 행사, state action이 있다라고 얘기를 하고 있고. Okay, so let's go to, if you don't have any more questions, let's go to 1088. Orville versus CBS 60 Minutes. Okay, we have 60 Minutes too. KBS, 추적 60분. 추적 60분이 바로 CBS의 아주 유명한 60 Minutes. 그래서 영감을 받아서 시작을 한 거죠. So, what happened here? It was a CBS documentary. I mean, this will remind you of like MBC PD 수첩 mad cow disease report, right? Similar. The investigative journalism does a lot of scientific stuff. So here, 60 Minutes apparently broadcast a program where chemicals sprayed on apples was harmful for people. So if you look at 1089, this is the statement. The most potent cancer-causing agent in our food supply is a substance sprayed on apples to keep them on the trees longer and make them look better. That's the conclusion of a number of scientific efforts. And who is most at risk? Children who may someday develop cancer from this one chemical called diaminoxide. And that statement, that children may develop cancer from diaminoxide, is the statement that apple growers, I guess Orville belongs to, apple growers sued CBS for, that it is a defamation. Okay. And you know, there is and then there's explanation of how this risk of diaminoxide has been really covered up by politicians. And if you look at 1090, the second paragraph, following the 60 minutes broadcast, consumer demand for apples and apple products decreased dramatically. The apple growers and others dependent on apple production lost millions of dollars. Many of growers lost their homes and livelihoods. Lost livelihood라고 하면 죽었다는 얘기는 아니고요. livelihood는 생계를 잃었다는 얘기입니다. 네. So, okay, this is a defamation case. And what does the court say about it? 이게 product disparagement 이라고 이제 얘기를 하는데, product disparagement 자, 미국법 공부를 조금만 하자면 page 1090 the fourth paragraph, right below discussion. We review the district court's summary judgment ruling then over. 딱 읽다 보면 여기서 그냥 이건 도대체 무슨 소린가 더 나갈 수가 없죠. 여기서 summary judgment는 약식 판결입니다. 약식 판결. 그래서 재판을 제대로 하기 전에 한국에서 왜 신민사소송법 통해서 이제 집중심리제도 들여왔다고 하죠. 집중심리제도 배운 사람, 민사소송법 시간에. 민사소송법 배운 사람 있어요? 아, 없구나, 민사소송법. 민사소송법에 보면은 집중심리제도가 뭐냐면은 미리 증거를 다 서로 준비하고 서로 증거 개시를 다 충분히 한 다음에 증거 개시라는 건 서로 보여주는 거죠. 보여주고 그리고 이제 재판은 딱 몰아가지고 뭐 하루든 7일이든 몇 달이 될 수도 있죠. 증거 개시 한꺼번에 해가지고 재판 가는 걸 이제 이걸 집중심리제도라고 하는데, 재판 갈 필요가 없이 그냥 여기서 그때까지 게시된 증거만 가지고 그냥 판결을 내리는 걸 이제 서머리 저지먼트라고 해요. 서머리 저지먼트. 헌법 시간이니까 뭐 더 이상 알 필요는 없을 것 같고, 여튼 the bottom paragraph, the growers offered evidence showing that no studies have been conducted to test the relationship between ingestion of diaminoxide and instance of cancer in humans. The bottom paragraph, the growers offered evidence showing that no studies have been conducted to test the relationship between ingestion of diaminoxide and instance of cancer in humans. So, to prove truth or to prove falsity, the growers offered the evidence that no studies have been conducted to test the relationship between diaminoxide and cancer in humans. What does the court say about it? The court says, such evidence is insufficient to show genuine issue. Such evidence is insufficient. Animal laboratory tests are legitimate means for assessing cancer risks to humans. Right. The next page, 1091. The second paragraph, the growers' only challenge to the scientific studies is their claim that animal studies cannot be relied on to indicate cancer risks for humans. And growers point to these statements made during the broadcast. What we are talking about is a cancer-causing agent used on food that EPA knows is going to cause cancer for thousands of children over their lifetime. Natural Resource Defense Council has completed the most careful study yet on the effect of diaminoxide and 7 other cancer-causing pesticides on the food children eat. Over a lifetime, 1 child out of every 4,000 or so of our preschoolers will develop cancer just from these 8 pesticides. So growers are saying, okay, this was never tested on children. Therefore, it is false. And the court is saying, hey, when you say false, it means that they actually have to prove that diaminoxide does not cause cancer risk to children. And growers could not do that. It's not like CBS has to show that actually 1 out of 4,000 children actually contracted cancer. Projection from animal studies is enough to raise doubt. Now, you can compare this to the mad cow disease cases of the Korean court. There, the court actually decides that it is false that mad cow disease is caused by substance in American beef. But the thing is, it was never scientifically proven that mad cow disease or the substance in American beef does not cause mad cow disease. So you can see the standard of truth, standard of falsity is also different in Korean courts and American courts. Okay, page, let's see, let me just check something. Okay. Does anyone have a syllabus that I gave you guys? 이건 아니죠. 네, 네, 이거 말고 거기에 아니 그거 아닌데. 아 이거 아니에요. 그거 아니고. 오케이, 그럼 제가 좀 더 확인해 보고. Heps case. What 말고 Heps case, page 1148. So this case is about whether a person can recover for defamation without showing the falsity. So here, defendants published, page 1149, the second paragraph. The defendants published 5 stories between May 1975 and May 1976 about Heps and the corporation of which he was principal stockholder, claiming that they had the links to organized crime and had used those connections to influence the state's governmental processes, both legislative and administrative. And here, what happened was and also the court talks about the reporter's shield law. Pennsylvania shield law. Pennsylvania shield law, we don't have law like that in Korea, but it allows the media companies to be silent about their sources. So these media companies basically wrote an article saying Heps was linked to organized crime without revealing their sources. Why would American society have a law like this, reporter's shield law, that allows reporters to hide their sources? Or if all the reporters are required to disclose their sources, there will not be tips given to the reporters. There will not be anonymous tips because, if their identities will be revealed, it's not just safe for them to give tips to the reporters. So it is to protect the media's role in criticizing and monitoring the powerful people. Anyway, the problem is because of the Shield law, they could not prove, right? They could not prove that they had they thoroughly investigated the possibility of falsity. They could not show because they could not disclose their sources, and without disclosing their sources, they could not prove that they were diligent in making sure their stories were correct. So, fault was proved. That they were not diligent. The fact that they were not diligent in checking the truth of the stories, that was proved. But what was not proved is whether the story was false at all. Whether Hepps was actually linked to organized crime. So in the lower court, Hepps did not prove that he was not linked to organized crime, but he only proved that the media companies were not diligent in checking the truth of the stories. So the court is saying that to prove, to win on damages, to win on defamation, plaintiff have to prove falsity. And who has the burden of proving the falsity? Plaintiff. Now, some people are worried because if you put the burden of proof of falsity on the plaintiff, a lot of times it is difficult because you usually have to prove a negative statement. How do you prove that I'm not? So to sue you, right? To sue, let's say you are the media, to sue you for saying that I'm connected to organized crime, I have to prove that I'm not. It's a negative statement. How can I prove that I'm not organized? I'm not linked to organized crime? What does it mean, linked, right? That I meet with organized members of organized crime, that I work with organized crime. How do I prove that I did not work or meet with them? It's easier to prove that I met with them, but it's very difficult to prove that I did not do something unless I keep a like hour by hour log of my daily activities and showing none of them includes meeting or working with organized crime. So that's why the court says, the bottom paragraph on page 1150, we recognize that requiring the plaintiff to show falsity will insulate from liability some speech that is false but unprovably so. Nonetheless, the court's previous decisions on the restrictions that the First Amendment places upon the common law of defamation firmly support our conclusion with respect to the allocation of burden of proof. In attempting to resolve related issues in the defamation context, the court has affirmed that the First Amendment requires that we protect some falsehood in order to protect some falsehood in order to protect speech that matters. To provide breathing space for true speech on matters of public concern, the court has been willing to insulate even demonstrably false speech from liability. So I mean, this case where court has been willing to insulate even demonstrably false speech from liability, one example of the court doing that is New York Times versus Sullivan, right? There, it was clearly false, and yet the court insulated New York Times from liability. What? To provide breathing space. So the court is here responding to the concern that proof of negative statement is inherently difficult, and that asking the plaintiff, asking defamation plaintiff to prove the falsity will actually exempt many actually false statements, because plaintiff will have a difficult time proving falsity. The court saying, hey, still doesn't matter. So this again shows how favorable for free speech is the Supreme Court, how favorable the Supreme Court is for free speech. Okay, we'll take a 15-minute break and we'll come back at 10:30. Okay, page 142 of the source book, Desnick versus American Broadcasting Company. So in this case, there was an undercover investigation of a eye clinic by ABC, a broadcasting company. So one of the agents, one of the reporters of ABC, impersonated to be a patient and went into the clinic and made a videotape of the conversations with doctors there. And then basically the program showed that the clinic overdiagnosed, right? Overdiagnosed 과잉 진료. So here, the defamation lawsuit does not work because this is truth. What if? How about invasion of privacy, right? given that the clinic was not open to the public, so someone by deception gained access to otherwise private space and videotaped what goes on in that private space. Therefore, this is invasion of privacy. That is ABC's, or that is Desnik I Center's argument. What do you think about this? First of all, is this a trespass? 주거침입. 네. Is this a trespass? Obtaining entry by fraud. Is this trespass? But that it is a trespass, if it is a trespass, does it mean that publishing something that they saw during the entry is also invasion of privacy? If you look at page 1172, the second paragraph, right in the middle, 2, 4, 6, 8, 10, 12, 12th line. A restaurant critic could not conceal his identity when he ordered a meal, or a browser pretend to be interested in merchandise that he could not afford to buy. Dinner guests would be trespassers if they were false friends who never would have been invited had the host known their true character. And a consumer who, in an effort to bargain down an automobile dealer, falsely claimed to be able to buy the same car elsewhere at a lower price would be a trespasser in the dealer's showroom. Some of these might be classified as privileged trespasses designed to promote competition. Others might be thought justified by some kind of implied consent. So here, these are the examples where 5 lines down, the fact is that the consent to an entry is often given legal effect even though the entrant has intentions that, if known to the owner of the property, would cause him for perfectly understandable and generally ethical or at least lawful reasons to revoke his consent. So that entering upon another's land without consent, it's not always wrong. All the way at the bottom. Yet we know that to conceal the fact that one has a venereal disease, 성병이죠, transforms consensual intercourse into battery, 폭행. 예. Seduction, standardly effected by false promise of love, is not rape. 그렇다고 해서 유혹할 때는 뭐 상대한테 뭐 별도 따준다, 달도 따준다 얘기를 하지만 그런 허위의 약속을 했다고 해가지고 그게 강간이 되는 건 아니다. Intercourse under the pretense of rendering medical or psychiatric treatment is at least psychiatric treatment is rape, at least in most states. 근데 의료 빙자해서 성추행한다거나 이거는 강간이다. 그러니까 뭔가 구별하는 방법이 있어야 된다는 거죠. 네. 그러니까 모든 위계에 의해서 all entries procured by fraud or deception do not count as trespasses. So what deceptions, right? What deceptions negate consent and what other deceptions don't? So think about it, okay? Think about it. I mean, this is a very interesting case. And the court knows that the lines are not bright. It's difficult to, you know. So for instance, let's say, I mean, one example I can think of is, let's say I get married. I marry another person. But under the false pretense that I'll have sex with that person. Okay? But in fact, when I get married, I have no intention of having sex with the person. I'm so in love with my bride that I don't need to have sex. I don't want to have sex because we are in perfect love, right? Is that marriage? I mean, I was trying to think of the most difficult case that you could think of, that it's hard to distinguish, they're hard to categorize in one group as opposed to the other. Is that a marriage? Is that marriage procured by fraud, void, or do you have to get a divorce? 그 결혼은 위계에 의해서 얻은 거기 때문에 무효인지 아니면 이혼을 해야 되는 건지. So, you know, I mean, the examples that the court gave are easier ones, right? But there is a difficult one like this. So just think about that, and I mean that just shows how much Constitution, although the court case doesn't talk about Constitution, in the end, it shows how much the Constitution protects media's freedom of speech or media's freedom to report by investigation, by undercover investigation. Page 1202, page 151, there's a Melvin versus Reid. So page 151 of the source book, 1202 of the original case book. Look at the notes, number 1, painful truth. Melvin versus Reid. Plaintiff was a former prostitute who had been tried for murder and acquitted. After her trial, she reformed her character, married into respectable society, gained the friendship of many persons who did not know her past life. Several years after plaintiff's marriage, the defendants made and exhibited a film that told the true story of her past using plaintiff's maiden name. Plaintiff sued damages when she was scorned and abandoned by her friends, the film having exposed her to obloquy, contempt, ridicule, causing her grievous mental and physical suffering. After reviewing the law of privacy, the court sustained plaintiff's cause of action, concluding defendant's use of plaintiff's name after she had reformed was not justified by any standard of morals and ethics known to us and was a direct invasion of her inalienable right guaranteed to her by her constitution to pursue and obtain happiness. Whether we call this right of privacy or give it any other name is immaterial. Okay. So this was a true speech, and yet it was actionable. actionable은 이제 소송거리가 된다는 얘기입니다. action은 소송을 얘기하는 거고. Why? Invasion of privacy. But her life was not really secret because she was tried for murder. tried는 재판받았다는 얘기입니다. The fact that she was a prostitute probably became public during the course of the trial. So the filmmaker basically used the publicly available facts and made a film. The court thinks this is actionable, whether it's for invasion of privacy or not. Okay. Now, think about that, Melvin versus Reid. And then let's go to source book, page 153, Cox Broadcasting Corporation and Cohn. This was a rape victim. Okay. Again, her name. So it's really difficult to read this, but page 153 of the source book. In August 1971, Appellee's 17-year-old daughter was the victim of a rape and did not survive the incident. So probably she was killed during rape. 6 youths were soon indicted for murder and rape, although there was substantial press coverage of the crime. Of a subsequent development, the identity of the victim was not disclosed pending trial. In April 1972, or the very bottom of the page, in the course of the proceedings that day, appellant Wassell, a reporter covering the incident for his employer, learned the name of the victim from an examination of the indictments which were made available for his inspection in the courtroom. That the name of the victim appears in the indictments and that the indictments were public records available for inspection are not disputed. And then Wassell broadcast over Cox Broadcasting Corporation a news report concerning the court proceeding. The report named the victim of the crime and was repeated the following day. So is this invasion of privacy? What do you think about this? Now the court thinks it's not an invasion of privacy. The court thinks the press should be able to report on the information that's publicly available. And the name of the rape victim was in the indictment. So the court is basically saying media should be able to report anything and everything that is in the public records. What do you think about this? Which court do you think decided correctly? Melvin versus Reid, which is the California Supreme Court case, or Cox versus Kahn. This has a lot to do with constitutional freedom of speech, because what do you do when publicly available information, publicly available truthful information is made available to a greater circle of people? Here, indictments were made available in the courtroom, and became part of public records. Same thing with Melvin versus Reid. Because she was tried for murder, I mean, any murder trial in any community will be publicly known, will be available for public scrutiny. So, page 1206. The second paragraph, about 10th line from the top. Whether the state may impose sanctions on the accurate publication of the name of a rape victim obtained from public records, more specifically from judicial records which are maintained in connection with the public prosecution and which themselves are open to public inspection. We are convinced that the state may not do so. Page 1207, 1 to 3, third paragraph from the top. We are reluctant to embark on a course that would make public records generally available to the media, but forbid their publication if offensive to the sensibilities of the supposed reasonable man. Such a rule would make it very difficult for the press to inform their readers about the public business and yet stay within the law. The rule would invite timidity and self-censorship and very likely lead to suppression of many items that would otherwise be put into print that should be made available to the public. So all the way at the bottom, the court says, once true information is disclosed in public court documents open to public inspection, the press cannot be sanctioned for publishing it. So Melvin versus Reid and Cox versus Kahn conflict with each other, contradict each other. Which one do you think is the correct rule from your view of privacy and freedom of speech? And how is your decision related to how Korean law treats the same matters? Think about it.
Professor,
Yes?
can I ask a question?
Okay.
What is the type of this lawsuit? Is it constitutional or
Nope.
criminal?
Civil.
It's civil.
Yeah. 민사소송법이죠.
Okay.
Yeah.
So aside from that, is criminal the public in full
It becomes part of public records, yes.
with the full name and
Yes,
information?
yes. What it does is you can petition the court to make some names secret. And here, I guess, people just didn't think much of the rape victim's fate. Probably because the rape victim has died. Probably they thought, okay, she has died anyway, so there is not much privacy to be protected. But it's the family who suffered.
Is Melvin versus Ray case also a case between private party versus the media?
Melvin versus, yes. Also.
And they are both civil lawsuits.
Yep.
So in the U.S., is there a law that protects deceased person's reputation, like in Korea?
No,
No.
no. And also, if it's a reputation, is the reputation hurt here? What is reputation? Right?
On a person. So deceased is not a person?
No, reputation. I mean, how is reputation hurt? Right? Truth. True statement does not hurt reputation, remember. Right? It's privacy that's hurt. So, if you think about it, even in Korea, revealing truth about a dead person should not come under, 사자 명예훼손. If you are true, if you want to remain faithful to the meaning of reputation. Just for a second. Okay, let's do a little bit more. Page. Okay. 그러니까 지금 한 게 다 참고자료 부분이죠. 참고자료 부분이고 노동조합과 업무방해, 판례집, 스톤, 윌리엄스 판결. 오케이. Page 165, source book. So we read Brandenburg versus Ohio, and there we established that freedom of speech is protected by strict scrutiny, which requires a clear present danger to be proved before speech can be punished or persecuted. So there, even Ku Klux Klan, KKK leader making vengeful speech with the guns present, threatening to march in major cities, were not considered to be presenting sufficient clear and present danger to punish the KKK leader. Or how about in this new case, Hess versus Indiana? So during an anti-war demonstration, he said, "We'll take the fucking street later again." So what happened was there was anti-war demonstration and the police shoo them away. And as the demonstrators were retreating, they said, oh, we're going to come back. So the idea was that those words that were going to come back were supposed to incite other people into engaging in more violations of the police request. Okay. The police, so basically the police disbanded the demonstration, and he was threatening, and he was threatening loudly, so thereby encouraging others to come back and start the demonstration again, which is by now illegal because the police has disbanded them. What did the court say? The court said, the statement could be taken as a counsel for present moderation at best. At worst, it amounted to nothing more than advocacy of illegal action at some indefinite future time. Right? Watch the words. We'll take the street later. Which means we're not going to take the street now. So in the test of clear and present danger, danger was not present because it was not immediate action that he was threatening. You see how this is related to Brandenburg? In Brandenburg, KKK leader said, oh, we're going to march at some point in the future. Oh, we're going to take vengeance against the Jews in some future. That's not immediate enough for speech to be punished. And then NAACP versus Claiborne Hardware. This was against not one person, but one group, NAACP. So NAACP boycotted merchants in Claiborne County because Claiborne County continue to county 이제 우리나라 따지면 군이라고 생각하시면 됩니다. 군청. County engaged in some racist policies. So to protest against that, NAACP organized strike, 불매죠, 불매. Not against the county government, but against the white merchants. So it was not like direct protest, it was a secondary protest. And there, during the course of the boycott, boycott이 불매죠. During the course of the boycott, Charles Evers, NAACP official, stated in a public speech to several hundred people that if we catch any of you going in any of them racist stores, we're going to break your damn neck. On the basis of this and similar statements, a state court found that fear of reprisals had caused some black citizens to withhold their patronage, 애용, 그러니까 그 가게의 이용을 withdraw, withhold, 자제하게 됐다는 거죠. In an action brought by the white merchants, the state court declared the boycott unlawful and held the organizers liable for all damages resulting therefrom. The Supreme Court reversed What did the Supreme Court say? In the passionate atmosphere in which speeches were delivered, they might have been understood as inviting an unlawful form of discipline, or at least as intending to create a fear of violence, whether or not improper discipline was specifically intended. discipline 이제 처벌, 그러니까 제재, 그러니까 breaking a neck, 그게 이제 제재죠. 보이콧 불매니까 딴 사람이 못 들어가게 하는 게 이제 중요하니까. This court has made clear, however, that mere advocacy of the use of force or violence does not remove speech from the protection of the First Amendment. The emotionally charged rhetoric of Charles Everett's speeches did not transcend the bounds of protected speech set forth in Brandenburg. The lengthy addresses generally contained an impassioned plea for black citizens to unify, to support and respect each other, and to realize the political and economic power available to them. In the course of those pleas, strong language was used. If that language had been followed by acts of violence, substantial question would be presented whether Everett could be liable for consequences of that unlawful conduct. In this case, however, the act of violence occurred weeks or months after the speech. Weeks or months after the speech. So violence actually happened, right? Violence actually happened, but only weeks or months after the speech. Strong, effective, extemporaneous rhetoric cannot be nicely channeled in purely dulcet phrases. 아름다운 송가로 선동을 할 수는 없다. An advocate must be free to stimulate his audience with spontaneous and emotional appeals for unity and action in a common cause. When such appeals do not incite lawless action, they must be regarded as protected speech. To rule otherwise would ignore the profound national commitment that debate on public issues should be uninhibited, robust, wide open. So the reason we are reading these cases is we want to see how far this clear and present danger test goes. Let's just read one more. Williams, page 167. Here, basically, Williams was working at a store, and he wanted to get his wages paid, back wages. And the store owner, Canizaro, left column, the third paragraph at the bottom, Canizaro replied this was special exception and reiterated that Williams would have to wait until the next business day to collect his check. Williams then shifted his body sideways and put his hand on his hip, stating, "Mother F, you better give me my check." Over Williams' shoulder, Marsh mouthed the words, "He has a gun." Canizaro was frightened and gave Williams his check. As Williams turned to leave, Canizaro saw what he believed was the handle of a gun protruding from Williams' pants. Before exiting the store, Williams turned and said, "Don't make me strap your ass." Okay. So here, so we read Brandenburg, we read Claiborne, we read Hess, and we know how immediate harm has to be before speech can be restricted. Here, if you read the statute that was applied to Williams, it's the criminal harassment statute. A person is guilty of harassment if, without lawful authority, the person knowingly threatens, threatens what? Threats to cause bodily injury in the future to the person threatened or to any other person. Or maliciously to do any other act which is intended to substantially harm the person threatened or another with respect to his or her physical or mental health or safety. Okay, so to cause bodily harm in the future, that I don't think passes clear and present danger test because it's in the future. I'll kill you in 100 years. Well, I'll say I'll be dead after 100 years. So statements like that do not count. So that's easy. What's more difficult is this part. Maliciously do any other act which is intended to substantially harm the person with respect to his or her physical mental health. So the question is, can mental health be a harm? Can constitute a clear and present danger for which speech can be restricted? What do you think about that? So, there are speeches, okay? There are speeches that there are threatening speeches that are constitutionally there are threatening speeches that it is constitutional to restrict, and we call them true threats. Page 169 of the source book on the right side, second paragraph. A definition of true threat has emerged in the wake of Watts. So Watts was the case where at a anti-war rally, 반전 시위를 하는데 one of the veterans came out and he said, if they ever make me carry a rifle, 나한테 집총을 하도록 강요를 하면, 그러니까 나를 끌고 가면, 나를 징병을 하면 그런 얘기죠. The first man I want to get in my sights, sights는 관역을 말하는 거예요. 관역이 아니라 그거 뭐라 그래요? 제가 잘 모르는데 총 위에 달려 있는 군대 갔다 온 사람 없나 여기? 네, 총 위에 달려 있는 그건 것 같아요. 네. 가늠쇠 안에 넣는 거는 LBJ 대통령. 그러니까 집총을 시키면은 나는 그걸로 대통령을 쏘겠다. 라고 얘기를 한 거죠. 그거에 대해서 이제 경찰이 체포를 했는데 대법원에서 뭐라고 했냐면은 이거는 실제로 대통령 죽이겠다는 게 아니라 그리고 논리적으로 그렇잖아요. 징병을 당하면 하겠다는 거 지금 당장 하겠다는 게 아니잖아요. 그러니까 clear present danger 없다고 본 거죠. 그렇게 하면서 뭐라고 얘기했냐면 그 밑에 패러그래프에서 A definition of true threat has emerged in the wake of what a true threat is a statement made in a context or under such circumstance wherein a reasonable person would foresee that the statement would be interpreted as a serious expression of intention to inflict bodily harm upon or to take the life of another individual. Now the question is whether this whether this threat to mental health also qualifies as clear and present danger. What do you think? Well, the court, this is a Washington State Supreme Court, they struck down, saying mental health is just too overbroad. Think about that. This is a very important decision here. And this is why America does not have hate speech law. And in Korea, there are calls for regulation, speech regulation, whenever you encounter harsh words. 뭐 세월호 피해자들 뭐 오뎅에 비유한 거는 인륜에 반하니까 처벌해야 된다. 뭐 많은 심한 말들에 대해서 우리가 처벌의 목소리를 높이는데 미국 법에서는 기본적으로 멘탈 헬스에 대해서는 그것이 표현의 자유를 표현의 자유에 대한 규제를 정당화할 수 있는 명백하고 현존한 위험이라고 보지 않는 거예요. 왜 그럴까요? Because mental health, it's hard to really have a sense in an objective manner. I mean, we talked about this in light of the law of insult, right? How, whether you are insulted or not, depends on your self-assessment and how other people view you. Right? Okay, we'll end there. Now we're gonna follow the syllabus from this point on. So 이 syllabus 나눠드린 거 꼭 보세요. 그래서 다음 시간에는 이 6주차 인터넷상의 표현의 자유부터 할 겁니다. 자, 마치겠습니다.